Okay, good evening and welcome to Resolving Conflicts of Interest and Establishing Boundaries, another of the legal ethics sessions from my program, Beit Midrash Zichron Dov. I want to thank Shari Shamayim for their willingness to partner on this program, and I look forward to the day when we will actually be able to have the programs together at Shari Shamayim. I want to thank Rabbi Chaim and Avital Strauchler, as well as Brian and Robbie Schwartz, for dedicating this session with their gifts to our Beit Midrash Day of Giving back in July. I also would like to dedicate learning this evening for a speedy recovery, a refuah shalema, for Yehudit Bat Simcha Nachma.
Yes.
Just letting in a couple of more people from the waiting room. If you signed in advance, if you registered in advance, via the form on the website, you don't need to do anything else. If you did not register in advance, then sending me your name in the chat is sufficient as registration. You could do it as a private message to me. You could do it openly, whatever you like. The only caveat is if you didn't get an email from me promoting this session, then please include your email address when you send me your name, because that way I will be able to send you your credit letter, which may matter. And also that way I'll be able to send you notification about future sessions. The next session is scheduled for Sunday morning, May 30th. 9:30 a.m. to 11 a.m. and that one will have EDI credit. I don't remember the exact title right now, but that's Sunday morning, May 30th. When I send out the follow-up email from this session, I will I'll send you the information about that session as well. This is actually a revised and updated version of a session that I gave back in May of 2015 at the Bayit. Perhaps some of you were there at the time. At the time, I built that based on lessons in Shiurim that I heard from Rav Hershel Schachter, Rabbi Yonah Rees, and also with the help of Jeffrey Silver for his legal research. So I'm grateful to all of the above for providing the basis for what we're going to discuss this evening. If you take a look on the sheet, and I'm going to share the link once again for it in the chat. Hang on one second. So I'm sharing the link again in the chat for people to download it. If you take a look at your sheet at the top, I gave you the agenda, the items that I filed with the Law Society as what we want to cover. Duty to avoid and manage conflicts of interest. And I included some questions there. What steps are necessary to determine the existence or absence of conflicts of interest? What constitutes a conflict of interest? How do we assess gray areas from the standpoint of contemporary practice as well as Jewish tradition? How should a lawyer manage relationships with clients effectively, particularly in the realm of identifying, respecting, and enforcing appropriate boundaries? And optional and mandatory withdrawal from representation. What options are open to a lawyer who feels unable to resolve a conflict of interest? I'm not really sure how far we're going to get down this list of items. We have an hour and a half, and the time can go quickly, but hopefully we'll at least touch on all of these items. Okay, so far so good. There are fundamental concerns in the secular legal system as well as in Jewish law regarding the possibility that justice could be warped or appear to be warped by outside interests. That's our concern. If you take a look on the sheet at source number 1 from the Law Society of Ontario, the rules of professional conduct, conflict of interest means the existence of a substantial risk that a lawyer's loyalty to or representation of a client would be materially and adversely affected by the lawyer's own interest or the lawyer's duty to another client, a former client, or a third person. The risk must be more than a mere possibility. There must be a genuine, serious risk, the underlining is my own, to the duty of loyalty or to client representation arising from the retainer. So if there's a possibility that a lawyer's own interests or other duties could interfere with the duty to the client, that is a conflict of interest. A relatively straightforward definition, I think, pretty uncontroversial. I brought you source number 2, passage out of the Talmud, where it defines a conflict of interest in a way that is very neat for Hebrew speakers. By the way, I forgot to mention in the beginning that first of all, I really appreciate it when people have their screen on during the session. So thank you to everybody who's doing that. It's much more enjoyable to have a session where you can actually see the people you're talking to. That's number 1. And number 2, if there are questions and comments during the session, I much prefer if people interrupt me or do the raise hand thing, that kind of thing, as opposed to writing a message in the chat. Especially because we have a lot of people signing in via the chat. It's hard to track the comments there. It's much easier if people do it out loud. So in source number 2, I brought you a passage out of the Talmud in which the sage Rava comments on the word in Hebrew for a bribe. The word is a shochad. And Rava said, why is a bribe forbidden? He says, once one accepts a bribe from someone, one's mind becomes close to the giver of the bribe. He is like his person, like the same person. One cannot see guilt for himself, meaning a person who receives benefit from somebody else starts to see their interests as her own, as his own. And then he says the word in Hebrew for a bribe is shochad, which he reads as shehu chad. It is one. Or it can be, it is sharp, unclear exactly, but more likely it is one, meaning the briber and the bribee see themselves as a single unit. And therefore the interests of the briber become the interests of the recipient of the bribe. And there's the danger. That will interfere with the responsibilities and loyalties of the person who has received that benefit. And that applies clearly in certain conflict of interest cases. So with that in mind, I call your attention to the vignettes that I put on the sheet. We're not going to discuss the vignettes in depth from the start, but I'm going to poll you after each one just to get a vague sense of where everybody is. So let's start with vignette number 1. While attending the same university between 2003 and 2006, Jonathan and Sarah were part of a student Facebook group, occasionally commenting on each other's status updates and uploaded photographs. Jonathan left Facebook in 2006, good for you, Jonathan, and has neither seen nor communicated with Sarah since. Jonathan has a lot of time on his hands, though, now. If a business wishes to retain Jonathan as legal counsel in 2015, for a suit against a business owned by Sarah, does Jonathan face a conflict of interest? I'm going to pause here on that, and I'm going to launch a poll because I learned how to do polling in Zoom, and I'm very excited. So I'm launching a poll with a question here. It's an anonymous poll. Is this a conflict of interest? Before we go further about how to resolve it, we'll just take a few seconds for people to chime in, either yes, no, or uncertain. Again, it's an anonymous poll. Nobody can see, who answers. Wow, the percentages are high in favor of no so far. I'm going to share the results in another 8 seconds. I'm just giving you a 30-second period to respond. 28, 29, 30. Okay, so I'm sharing the results so you can see for yourself. 33 people responded no, this is not a conflict of interest. The fact that you were Facebook friends 9 years ago. We've got 6 people saying uncertain and just 4 people saying it is a conflict of interest. I would note, though, that that's in total 43 responses and we have 62 participants. So maybe I should throw the other 23. No, sorry, the other, I can do math really. The other 19 on the uncertain pile. I don't know, or on the eating dinner pile, I suppose. Either way, the general trend is to think it's not a conflict of interest among those who are here. We're going to come back to this and talk about friendship as a potential conflict of interest. But as I put in the rest of the vignette, if this is considered a conflict of interest, what can Jonathan do in order to represent the business? Is there any way out of it? And if it's not a conflict of interest, is Jonathan required to inform the business of his connection to Sarah at all? Does he have to say anything if it's not a conflict of interest in the first place? So that's vignette number one. Just basics of identifying conflict of interest, how to deal with a conflict of interest. And then let's take a look at number two.
Rabbi,
Yes, Gary.
I'm still considering it because I was downloading some of your material, but I used to do discipline cases when I was an elected bencher. And what I would do in a situation, if I was uncertain about whether there's a conflict, or I'm overly sensitive to that, I would tell the person being disciplined my feelings and ask them if they would like me to recuse myself, and we could adjourn the matter to another date. Then somebody else would be on the panel and not me. But that's what I would do if I was uncertain, or if I had any qualms whatsoever, because you don't want somebody to appeal later that you had a conflict of interest.
Right. And that's a major concern, certainly if you're a judge, that by staying on with a potential conflict of interest, even if it's not substantive, you open the door for problems later on. And that's definitely a consideration, as well as the overall point of, hey, mention it to people and let them decide whether they want to opt for something else, is also a remedy that we're gonna talk about.
And often they have their own lawyer as well. So
Yep. We're going to come back to that. Well, case number two, vignette number two, was an outgrowth of a comment that someone made when we had this session in 2015. And then when I announced I was going to be revisiting the topic, someone again emailed me about it. I think it might have been the same person who made the comment in 2015. And that is about the practice of conflicting out somebody. Something that I understand is a well-known practice, in particular in family law, but it exists elsewhere as well. So here's the second.
What's the expression?
Well, we didn't read it yet, but it's conflicting out or conflicting out. I'm not sure which way to put the accent. Well, let's talk about it in the context of the case. When Kimberly bought her home inspector assured her that no radon test was needed because radon was not prevalent in the area. 10 years later, Kimberly developed lung cancer, which she believes is due to radon gas emitted by the soil below her home. Kimberly sues her home inspector. Her lawyer, David, is aware of experts who would disagree that radon had caused her cancer, and he proposes meeting with them as possible experts in order to create a conflict of interest disqualifying them from the case. Since they met with us, they can't now serve as experts for the other side. Now, whether this strategy would work or not is an interesting question. My friend Jeffrey has told me that in Canada, this is less likely to be effective than in the United States. I'm not sure based on what I've read. But my question to you is, let's say this strategy is ethical, because we know that, not ethical, excuse me, is effective, because you know that it is effective in other areas like in family law. So the question is conflicting out lawyers ethical? So here I am going to, I'm going to give you a new poll. Let's see. Hang on. I'm going to give you a new poll here and 30 seconds to answer this. Again, this is an anonymous poll. Is David's strategy ethical? Yes, no, or uncertain? Wow, the no's are piling up.
Doesn't mean it's illegal. It's just unethical.
I didn't say illegal. I asked if it's ethical or unethical.
Why does the expert have to meet with them?
Because the idea is that you establish a relationship.
No, but why, when the expert understands the position or is invited to meet with them, why doesn't he just say, I'm not going to meet with you?
Oh, the expert can choose to do whatever they want.
Right.
Yeah. Okay, I'm going to end.
Rabbi Turchina.
Hang on one second. I'll just announce the results of the poll, and then I'll come to you, Yechiel.
Okay.
We had 50 people respond to the poll. 32 said this is not ethical. 13 said, here, I'll share the results. 13 said that it is unclear to them or uncertain. And 5 said, no, this is an ethical strategy to offer. And we're going to discuss these. I'm just getting a sense of where people are on it. Yes, Yechiel.
You should not, before the voting is closed, say which way it's going, because that in itself will influence the results.
Okay, fair enough. The polls have not yet closed in Vancouver.
Right, you remember that.
Yes. Okay. So that's our second vignette. And then the third vignette, which I hope to get to, because this is actually revisiting something. In the previous session, we discussed the topic of supporting the emotionally unstable client or something along those lines. I don't remember exactly what the title was. And I wanted to get to boundaries there, and we really ran out of time to do it properly. So I put it into this session, hoping we would get to it here. Rhonda, a corporate lawyer, has been managing her firm's relationship with NPO Pharmaceuticals for the last 7 years. Over that time, she has shared weekly communications, at least, with the pharmaceutical company's CEO, Sam. One day, Sam invites Rhonda to dinner, alone, to celebrate the good work Rhonda's firm has done for his company. Rhonda is uncomfortable, feeling that this is more personal than business. How should Rhonda navigate the need to maintain good relations with Sam while preserving appropriate boundaries? And here, the poll that I want to put before you is not how to navigate it, which is a very broad and open question, but is Rhonda's concern about the dinner invitation justified? This is, again, an anonymous poll. Yes, no, or uncertain. Is her concern justified? "20 seconds to go." "10 seconds to go." Not giving any answers, Yechiel.
You're assuming, Rabbi, you're assuming Sam is not gay.
So I didn't want to get into this. And actually, originally, I had made it a gender neutral question and I used Sam that way. And then I somehow slipped with the word his. I didn't mean to have that. So, yes.
I didn't catch that.
Don't worry about it. I'm sharing the results here. The answer from most people here is yes. Rhonda's concern is justified. 30 people said yes, 13 said no, and 8 said uncertain. So that's 51 responses out of, well, I'm one of the windows. So out of 64 windows. So 13 people are still eating dinner. But this gives us a general sense, I think, of where people are leaning. So let's talk this through in terms of the different aspects of it. And what we're going to find, I think, is that Jewish law and the secular system are actually in sync with each other for much of this topic. Not entirely so. There are some differences, but they're pretty close. In the secular system, we have a fundamental competition between, on the one hand, concern for conflict of interest, and on the other hand, being too restrictive as a result of that concern. If you take a look at source number 4 on the sheet, from McDonald Estate v. Martin, the specifics of the case don't affect the excerpt here. In determining whether a disqualifying conflict of interest exists, the court is concerned with 3 competing values. 1, the concern to maintain the high standards of the legal profession and the integrity of our system of justice. Obviously, that leads towards stringency regarding conflict of interest. 2, the countervailing value that a litigant should not be deprived of his or her choice of counsel without good cause. If you are going to conflict out lawyers, it's going to be harder for them to find the representation they want. And 3, from the lawyer's perspective, the desirability of permitting reasonable mobility in the legal profession. We want lawyers to be able to work, and you could run into a situation in which you become so strict regarding conflict of interest that you really restrict the ability of a lawyer to practice. And one of the areas that we're not going to go into in this session is the possibility that when one lawyer at a firm has a conflict of interest, you could actually conflict out the rest of the firm, depending a little bit on firm structure and the rules that they have in place and what kind of case it is. So you could really end up damaging the ability of lawyers to practice by being strict on conflict of interest. I reposted the link to the source sheet in the chat for those who just joined. So the two reasons why we are concerned about conflict of interest, why is conflict of interest such a big deal, are represented in source number 5 from the Law Society, from the commentary and the rules of professional conduct. The value of an independent bar is diminished unless the lawyer is free from conflicts of interest. The rule governing conflicts of interest is founded in the duty of loyalty, which is grounded in the law governing fiduciaries. The lawyer-client relationship is a fiduciary relationship, and as such, the lawyer has a duty of loyalty to the clients. That's concern number 1, as I underlined it. The lawyer has to be loyal to the client. Competing interests can take away from that loyalty. That's number 1. But it continues. To maintain public confidence in the integrity of the legal profession and the administration of justice, in which lawyers play a key role, it is essential that lawyers respect the duty of loyalty. This is a separate consideration. Public confidence in the legal profession. Aspects of the duty of loyalty owed to a current client are the duty to commit to the client's cause, the duty of confidentiality, the duty of candor, the duty to avoid conflicting interests. All of these are part of loyalty to the client. Current clients must be assured of the lawyer's undivided loyalty, free from any material impairment of the lawyer and client relationship. So there's a lot to be said about this, but those are our basic concerns. Will you be loyal to the client, and will we have a truly independent bar? The truth,
Rabbi,
yeah.
okay, if I interrupt you too much, please don't hesitate to tell me. But what you said a couple seconds ago about a lawyer perhaps being too restrictive to avoid conflict of interest. I remember I organized a program a number of years ago, and a very well-known family law lawyer said this: when somebody phoned her office to retain her, she never took the telephone call, never spoke to them, always had to be through the secretary, because people quite often phone to ask about retaining a lawyer. And if she wasn't retained or didn't want to be retained, she didn't want to disqualify.
Right, well, that's right.
Have to disqualify herself because a person on the other side phoned or what have you. So I think that's a consideration as well.
Yeah, no, that's the conflicting out that we were talking about in the second vignette. You're 100% right. So from a secular perspective, we have these two considerations. Lawyer has a fiduciary relationship with the client, and the legal system in general being viewed as a system of integrity. Those are our concerns. From a Jewish law perspective, keep in mind, and we've discussed this on other occasions, there is no formal position of a lawyer in the Jewish legal system. There are to'anim, right? People who help to structure a person's claim. There could be a mursheh. You could assign somebody to speak on your behalf in a rabbinical court. Now, today, we have positions that are more lawyer-like as well, but historically, you didn't have the literature that would speak to lawyers specifically, but the same concern of conflict of interest can be found in the Jewish legal system overall. Number one, because just like we say here, the lawyer has a fiduciary relationship with the client. In general, Judaism has the concept of hiring a professional and expecting that the professional is not going to self-deal and instead is going to take care of the needs of the person who hires them. So if you take a look at source number 6, a simple statement of it, a midrash on the verse, Lifnei Iver lo titein mechshol, do not put a stumbling block in front of the blind. So an example of putting a stumbling block in front of the blind is if you give somebody advice telling him, I want you to sell your field and buy a donkey. I think it will be good for you to get rid of that real estate and buy a donkey instead, because you want to buy the field from that person. So that's a case in which you're serving your own interest instead of the other person's interest and giving bad advice. It's a short step from that to the professional who's actually retained to give advice and give self-serving advice. If you take a look at source number 7, we have a discussion in the Shulchan Aruch and the Code of Jewish Law about a legal guardian and the limits of what a legal guardian is able to do in investing the assets that are under the guardianship. So Rabbi Moshe Isserlis writes, some say that just as a guardian may invest with others, so he may accept it for his own ventures. In other words, a legal guardian is responsible for assets and invests those assets. So let the guardian be able to invest it in the guardian's own ventures. So Rabbi Isserlis says, sure you can, so long as the rabbinical court oversees it. You still need to make sure that there will be oversight by the court due to concern for gossip. And that brings us to the other piece of it, which is public trust in the system. And this is a major theme in Jewish law, concern about trust for the system, because people become biased and therefore their actions are called into question. This in Hebrew is called nogea badavar. If you have contact with a matter, you have an interest in the matter, you can be disqualified. Interesting application of that in source number 8. The Jewish calendar is neither solar nor lunar. It's actually lunisolar, right? The general secular calendar of society that we live in is a solar calendar. It's built around the year, the solar year. The Muslim calendar is a lunar calendar. It's built on a system of months. The Jewish calendar is lunisolar. On the one hand, our months are based on the cycles and phases of the moon. On the other hand, certain events during the year are tied to particular solar seasons. So the holiday of Passover, coming up soon, is tied to the spring. Therefore, basically 7 times out of every 19 years, we add a leap month to the calendar. Since the lunar calendar is on average 11 days shorter than the solar calendar, there's a need to make up 30 days every few years. So 7 times in every 19 years, we add a month. It's not, this year is not a leap year, but the next year is going to be a leap year. So in the old days, it wasn't a set system where you knew. There's something called the Metana calendar that every 19 years you're going to add in year 3, year 6, year 8, year 11, year 14, 17, 19. That's the way it works now. In those days, every year, the rabbinical court had to convene and decide whether to add a month to the calendar. Well, people had all sorts of vested interests in having an extra month or not having an extra month, right? It's actually pretty funny to remember. I use the word funny loosely. Last year, when after Purim, right, when we all went into lockdown, there was this big movement, especially in Israel, of people saying the rabbis should add a month to the calendar. We should have an extra month before Passover, make it a leap year, in order that we should be able to delay Passover, and that way we'll be able to be out of quarantine by then. We were so naive. Sure, just add a month. That'll take care of it. This whole COVID thing will be a memory by then. Nonetheless, people have vested interests in this. So if you take a look at source number 8, passage out of the Talmud, tells us that the king and the high priest are not allowed to be involved in the discussion of whether to add a month to the calendar. Why? Well, the king has his armies, and the king may decide, I do not want to add a month because then I have to pay them for more time. And the high priest, due to cold, because the priests work in the temple barefoot, and they don't want to end up having to carry out the service in colder weather. They'd rather push things into the warmer weather. They'd like to have an extra month. There's more to be said about the specific interests of the king and the high priest. But the point is, when you're managing public affairs, you're not allowed to have a conflict of interest. There we have grave concerns about conflict of interest. Interestingly, when it comes to your own matters, we are less concerned. So, for example, as Rabbi Avram Yeshaya Karelitz pointed out, also known as the Chazon Ish, a rabbi is allowed to give a ruling regarding his own chicken. In other words, the rabbi has a chicken and wants to know, is this kosher or not kosher? The rabbi is allowed to issue the ruling even though there's an apparent conflict of interest. So Rabbi Karelitz suggested in source number 9 that, it's simply, this is the way the rules are. God decreed that human beings will have concerns, will have potential biases and interests when it comes to judging cases, when it comes to setting the calendar, but not when it comes to their own kashrut issues. That was Rabbi Karelitz's answer. But I wonder if you couldn't suggest that the reason why we say the rabbi can answer his personal kashrut question, but can't judge cases that he has an interest in, is because of our concern about public affairs and public issues. We don't want to create a position in which you're weighing in on the overall calendar of the nation, or you're active in the legal system, and people are going to have concerns about your personal interests. What you do with your chicken, that's your business. We're less concerned about where that could lead. I don't know. It's a thought. That's a little bit of a digression, but overall,
I mean, it seems, Rabbi Sturgeon, it seems also, I mean, on that point, it's not just about the public system, but if you rule on your own chicken and your personal interest in being able to eat your chicken clouds your judgment and you declare it kosher, even though it's treif. So that's, a blot on your soul, right? It's between you and God versus harming another person, right? Like when you're ruling for somebody else, it's not just the public sort of the perception of what's right, but you can actually be affecting other people badly. Whereas, it's not just that, it's yours, but it's who is it affecting, right?
Right. No, I definitely hear that. The fallout is limited to yourself. So yes, I do hear that. Mark.
It's not limited. If you have a restaurant, you say, I take responsibility for my own kashrut. I don't need an outside mashgiach.
Right. So the question then becomes, what are the limits for this sort of thing? The how far would we go in allowing the person to testify, or in your case that you're giving, to provide kosher supervision? I am familiar with the practice of vadim, of rabbinical bodies that oversee kashrut in general, that even if the owner of the business is observant of Jewish law, they will not accept that person as the mashgiach for the business, because they have a vested commercial interest in the in declaring everything to be kosher.
But it's very similar to judges and people in politics putting things in escrow so that their shares are not going to be affected by the decisions they make
Right.
on the bench or in politics.
Right. They divest themselves of the interest. Correct.
Well, they put it in escrow. They don't divest themselves.
Right. Understood. I'm trying to use a fancy word. So let's talk about the first vignette. Now that we understand that in the secular system and in the Jewish system, we have concern for conflict of interest, both in terms of actual and in terms of the perception. How exactly do we define conflict of interest? So in the secular system, the first rule is that there are no rules. That's the first and most basic. I brought you an excerpt here, even though it's a 1978 case, which is quite a while ago, but it's a case that gets quoted a lot. So I thought it worth bringing. It was where there was an energy board that was reviewing a pipeline proposal. And the chair of the energy board had a prior role with a firm that had been contracted to build that pipeline. They were no longer involved with the pipeline, but had been on the project before. And the question was, does that constitute a conflict of interest? So if you take a look at source number 10, the proper test to be applied in a matter of this type was correctly expressed by the Court of Appeal. As already seen by the quotation above, the apprehension of bias must be a reasonable one, held by reasonable and right-minded persons, applying themselves to the question and obtaining thereon the required information. In the words of the Court of Appeal, the test is, quote, what would an informed person viewing the matter realistically and practically and having thought the matter through conclude? If you're a reasonable person, you've thought about it, will you look at this and say, yeah, that's a potential interest. That's a very non-specific guideline, right? It relies on us to be reasonable people. It relies on us to think it through. And whatever we come up with, yeah, that sounds right. So much so that they actually discouraged particular rules. If you take a look at source number 11, this was an appeal of a ruling where there was a judge in a case between two First Nation bands. And then after the ruling, it came out that the judge who had issued the ruling had had a prior connection to the claim of one of the parties. So in source number 11 here, this excerpt from that 2003 case, it cannot be addressed through peremptory rules. You can't define conflict of interest based on sort of, hard definitions. And contrary to what was submitted during oral argument, there are no textbook instances. Whether the facts as established point to financial or personal interest of the decision maker, present or past link with a party, counsel, or judge, earlier participation or knowledge of the litigation or expression of views and activities, they must be addressed carefully in light of the entire context. There are no shortcuts. We don't have rules. That's the way it is. However, we do have mitigating factors to consider. Let's say we approached this unlike the way the poll went, right? The poll decided that most felt that Facebook Friendship was not actually did not present an interest. Facebook Friendship that ended 9 years ago, and that was relatively casual to begin with. But even if it was a concern, Facebook Friendship was a concern, there are mitigating factors. One mitigating factor, indirect interest. If the interest really is not directly related. And I brought you the CN Rail case in source number 12. This is another very popular case. CN Rail versus McKercher. McKercher LLP had represented CN Rail in a bunch of different areas. Then somebody retained them to sue CN Rail. So CN Rail terminated one of their retainers of McKercher. McKercher terminated the rest of their retainers. But the question is, can they still represent the other side? Is it legitimate? So in source number 12, we're told the rule applies where the immediate legal interests of clients are directly adverse. It does not apply to condone tactical abuses, which we're going to come back to. And it does not apply in circumstances where it is unreasonable to expect that the lawyer will not concurrently represent adverse parties in unrelated legal matters. What is it with lawyers and double negatives? I don't know. It is unreasonable to expect that the lawyer will not concurrently. It took me a long time to untangle the spaghetti of this sentence. But basically what I think it's trying to say, correct me please if I don't understand, but what it's saying is that if it's reasonable to think that lawyers will end up representing adverse parties in unrelated matters, unrelated legal matters, if, saying there should never be any such conflict is unreasonable, then we're willing to go ahead with it so long as the interests are not directly opposite. Is that a fair statement of what you're seeing in number 12?
But you leave out the fact that one party may have access to confidential information of the other party and may affect the decision.
Right. So the assumption here is that there are no hard conflicts. It's not like there was a file that was shared. It's not like there's something that you can point to as a smoking gun, so to speak. It's more relationship based. You
may have access to financial figures.
Well, the way that the case, I think, in McKercher is framed is that there is no overlap, and that's the basis for saying there's no real concern. Also, if the interest is a small interest, then we tend to be willing to overlook it. And here I bring you from a guideline for judges as opposed to lawyers in source number 13, and just looking at the lines that I underlined. if the outcome of the proceedings before the judge could substantially affect such holdings. There has to be a substantial impact. If it's only a small impact, not such a concern. And then finally, passage of time, which is the most relevant for the Facebook discussion. You have a case in source number 14 in which a judge issued a decision, and then after the decision, one of the litigants recalled that 16 years earlier, he had retained the judge as a lawyer and discussed personal information with her. So a litigant says, I'm not saying that there was a bias at all. However, the judge should have stepped away because I hired her 16 years ago as a lawyer. Now, I think if I ran a poll here, I should have set up a poll. I'd be curious to hear how many people on this actually believe that the litigant completely forgot having hired this judge until after losing the case, and then magically remembered, oh, wait, I knew you were familiar. I looked in my records. Sure enough. I don't know. The literature presents it with a straight face. But if you take a look at source number 14, we're told, notwithstanding the passage of some 16 years since the time of the brief solicitor-client relationship, the lack of recollection of that relationship by both DGC and Judge Sachs prior to the release of the decision, and the independent concurrence of Justice Frank and myself in the decision authored by Justice Sachs, in my view, prudence dictates that the decision be set aside, this panel stand down from this matter, and a new panel be constituted by the Associate Chief Justice to rehear the appeal. So 16 years, not enough. And even though we think that the judge made the right decision. So maybe passage of time works. In this case, it didn't. So applying all of this to our case, our 9-year-old casual Facebook friendship, you can make the argument that this is a personal interest. In source number 15, in defining personal relationships, the Law Society says it's a conflict of interest if a lawyer has a sexual or close personal relationship with a client. However, the issue of Facebook friendships has actually been discussed and dismissed. If you take a look at source number 16, Heffel versus the Registered Nurses Association, and the case was where there was a board of inquiry that was investigating a nurse's conduct, and a member of the board was Facebook friends with a witness on the case. That was the story. And the decision was, this is not a conflict. Take a look at number 16. My review of cases where the issue has been dealt with indicates that while Facebook friendship indicates that the parties know each other, it does not, without more, establish that there is a relationship which would result in a reasonable apprehension of bias according to the accepted test. More evidence is needed. If you're going to claim conflict of interest, you're going to have to prove it beyond saying, look, they were Facebook friends. So you can't conflict out people by making them Facebook friends, right? You send invitations to all of the divorce lawyers and they now become your Facebook friends. That presumably would not succeed in conflicting them out. But they want to follow up. They want more information. It may be an indication of stronger interests. It should be followed up. This is all the secular system. Are we clear on the secular result? What about in Jewish law? So in Jewish law, we look at two different kinds of interest. One, financial interest, and two, friendship. In terms of financial interest, we're very clear. Source number 17, a verse in Exodus, you shall not accept a bribe. The bribe will blind the sighted and warp the words of the righteous. Or as Rabbi Yosef Karo in the Shulchan Aruch in the Code of Jewish Law said in source number 18, wherever a judge has potential benefit, and we're talking here pecuniary benefit, he may not judge it, can't judge the case. Not only that, the Talmud in Ketuvot in source number 19 says, even where the interest is on the side of right, the interest is something that is pushing him to actually judge accurately, to do what is believed to be correct, doesn't matter. The financial interest is financial interest, and the judge has to step away. When it comes to friendship, That also is cause if you're dealing with a judge. Again, we talked about not counting lawyers in this because of the lack of lawyers in the Jewish legal system originally. But a judge will have to step away due to friendship as well. Take a look at source number 20, please, from again the Shulchan Aruch, the Code of Jewish Law. One may not judge a friend, even if he's not a shushvin or his closest friend. Shushvin was a technical relationship going back to Talmudic times, in which when you got married, you had a circle of close friends who were responsible to give you gifts. And then when each member in that circle of friends got married, each member of the group was responsible to give a gift to that person who got married. So it's a circle of friends called shushvinin, and they have a close enough relationship that they're required to give each other gifts on their marriage. So even if you're not that close with this person, doesn't matter. You can't judge the case. Also, if it's somebody you hate, even if he's not an enemy, you don't seek to harm him, doesn't make a difference. The litigants must be equal in the eyes and hearts of the judges. Interestingly, you can testify on a case involving a friend or an enemy. That you may do. Take a look at source number 21, also the Code of Jewish Law. All who are disqualified to judge are disqualified to testify. Generally speaking, if you're not eligible to judge the case, you're not eligible to be a witness either. Other than a friend or enemy who may testify even though they may not judge. Tell me something. Why should you be eligible to testify if you're conflicted out as far as being a judge? What would you suggest?
First of all, there are a couple of people who testify. You're not going to be testifying by yourself. So there's somebody else as well. And I think that they were very, based on what the Talmud says over and over again, they were pretty thorough in investigating and questioning witnesses to isolate any kind of inconsistencies and so on.
Right. So that's an interesting idea Michael proposes. You have a very robust system of interrogation of witnesses. So therefore, we rely on the judges to figure it out if the witness is lying. Rabbi Yoshua Falk addressed this and offered a different approach, really a surprising one to me. In source number 22, Hebrews at the bottom of one side, English at the top of the next side, he said, in testimony, you testify about what you see. We don't suspect that you would intentionally alter it for love or hatred. This is not so in judgment, which depends on logic. One's mind changes due to love or hatred, even without evil intent. In the mind of Rabbi Yoshua Falk, his explanation is that you get biased in terms of your judgment of something, but not in terms of your perception. Your perception is not subject to bias. I think modern psychology would disagree with this assertion. Witnesses see that which they want to see.
Rabbi,
Yes, Sergio.
sorry. The same thing can be said for judges who, prior to being appointed judges, had an active either political opinion in life or militancy, or they were, for example, members of or council or active in certain charities or NGOs. They have their biases and opinions. And the question is, at what point, if litigants come before the judge in a type of matter that is that is relevant according to the judge's prior involvement. And I can think, for example, in criminal law or in family law, that could happen, that people have very strong opinions. At what point so you have a conflict of interest? You cannot judge this because you were a member of party X or NGO X.
Right. In the secular system, it's, again, left up to the observer to figure it out. There are no hard rules. Passage of time may help somewhat, but given what we saw about the 16 years not being sufficient, it's hard. In the Jewish system so far, what we're saying is personal friendship is going to potentially disqualify. Financial interest is going to disqualify. You may be able to testify, but to hear a case, to be a judge, no. And not only that, Jewish law actually goes much further in this regard as a matter of religious piety, if not letter of the law. Take a look at source number 23, where the Talmud describes what it calls shochad devarim, a verbal bribe. What is a verbal bribe? Like when Shmuel, one of the sages, crossed a river and someone extended his hand to him, help him across. Shmuel asked, "Why are you here?" He replied, "I have litigation." Shmuel said, "I am disqualified to judge for you. You gave me a hand crossing the river. I can't judge your case." Another sage, Amemar, was judging when a feather landed on his head. Someone removed it. Amemar asked, "Why are you here?" He replied, "I have litigation." Amemar said, "I'm disqualified to judge for you. You took the feather off of my head. Now I am predisposed to view you favorably." And finally, Mar Ukva spat before himself. He spat out some phlegm, whatever it was. Someone covered it. And again, Mar Ukva asked, "Why are you here?" He replied, "I have litigation." And Mar Ukva said, "I am disqualified to judge for you." Very, very careful in this regard. And again, I think that what you're dealing with here is not only the possibility of interest, but the possibility that it could make the system look bad. Would we recognize passage of time as a mitigating factor in the Jewish system? So if you're dealing with a financial relationship, the answer is yes. If you're dealing with a personal relationship, it's less clear. In Jewish law, financial relationships come to an end. And I'll explain here by showing you sources 24 and 25. Source 24 is the Talmud in Bava Batra. We have a rule that says that partners are allowed to testify for each other. Partners are able to testify on each other's behalf. This is regarding a claim to a field. So the Talmud asks, why? They have an interest in their testimony. They want to help out the partner. So the answer the Talmud gives is only if they first write, "We have no claim in this field that had formerly been owned jointly." That's the Talmud's statement. If they renounce any claim, if partner A renounces any claim to the field, then the partner A can testify that partner B actually owns it. I didn't give an adequate enough introduction to that, but it's okay, because what I want to go to is what comes next. The question then becomes the following, and the rest of the Talmud is what I'm now talking about here, is what follows this Talmudic passage. What happens if there is a Jewish community with a synagogue and a Torah scroll, and the Torah scroll is stolen, and then it turns up somewhere, and people who are members of the synagogue want to testify about the Torah scroll, that it was, that it belonged to their community. They witnessed the theft. They can identify the scroll. Are they able to testify about the Torah scroll? And the Talmud's answer is no. They can't testify about the Torah scroll because they have an interest in it. They daven, they pray in that synagogue. They need the Torah scroll. Therefore, how could they be eligible to testify about it? They have a vested interest. They can't say, well, we will renounce our right to that scroll because they need the scroll for themselves. You follow?
What are we worried about here? They're going to lie about a Torah scroll?
Something that's worth $30,000, $40,000, $50,000? Yes, possibly.
Oy.
Yes.
I mean,
no, that's the concern. Yes.
This is a religious object that,
Yes.
okay.
It's a valuable religious object, and people are human beings. But again, listen to the case carefully. And Paul, this is what I was referring to earlier today. What we're saying is this. The reason why the citizens of this city, the members of this synagogue, are not eligible to testify about the Torah scroll is because they need that scroll. Since they are going to personally benefit from the scroll when it is recovered, therefore, they're not eligible to testify. That's what the Talmud says. But that leads to a question, which is what Tosfot, Anthology of Commentaries on that passage in the Talmud, asks in number 25. It says, wait a minute. Even if they recuse themselves, even if they renounce any claim to the Torah scroll, At the time of the theft, it was their scroll. What good is renouncing now? At the time that the alleged theft took place, it was your property. You have a conflict of interest. And so Tosfot in source number 25 explain that in the eyes of Jewish law, a financial relationship can end. And when the financial relationship ends, the interest is over. It comes to a stop. As opposed to a blood relationship or a marriage relationship, which you can't just declare terminated. If you are somebody's relative by blood or marriage, at the time when an event takes place, and then something comes along to sever that relationship, it doesn't matter. You're not able to then become eligible to testify. It doesn't work that way. So again, different kinds of relationships. A financial relationship can come to an end, and then you can testify about issues that relate to the former financial relationship. A relationship of relatives, that does not come to an end. Even if it ends, you can't testify. It's considered to be a conflict of interest. I don't know how to apply this to a Facebook relationship. Would I view that as being like a close relationship such that it continues even after you're no longer in touch with each other? I think that's not clear.
I would posit that anybody that knows anything about Facebook, and I'm a long way from being an expert on that subject, that a Facebook relationship is not a relationship, and a Facebook friend most of the time is not a friend unless they were friends before they became Facebook friends.
Right. No, it's
This
what we
whole
said
thing
before.
is-
It's an indicator that there may be something to investigate. That's really what you look at it as. So
Rabbi Shina, can I ask the three examples you gave about the rabbis who disqualified themselves? We wouldn't it wouldn't be judged like that, would it? Would they be forced to step away, or is this something they just did voluntarily just to be
right. So
extra
that's what I
scrupulous?
meant when I said this is an act of piety. It's
Right.
not a firm requirement that they have to recuse for that, but Rabbi Karelitz, the Chazon Ish, says it was an act of piety for them to step away. So what we have so far is both systems recognize conflict of interest issues in financial relationships and in personal interests. The secular precedent seems to say that Facebook association alone is insignificant, but it should be investigated. Jewish law seems to go further in identifying risks, and it does seem to be concerned about certain kinds of interests, like the marriage relationship, even after the original connection has ended. But it's unclear what it would say here. I want to move into the second part of that first vignette.
Rabbi, just before you go there, one quick question.
Yeah.
If you were in the United States where judges carry political tags with them and have preconceived notions about issues that come, i.e. Roe versus Wade, which is going to go to the Supreme Court, would you be having the same discussion?
Why not?
Well, clearly in the United States, judges have tags. They have prior decisions. They have people study them and they quiz them and they ask them what their feelings are on certain issues, i.e. the abortion issue, which is going to come before the Supreme Court. So would you disqualify people because they expressed this opinion in the past?
I don't think, unless I'm reading the sources wrong.
As a conflict of interest? I mean,
Right.
surely it's a conflict of interest on the Supreme Court.
Having a personal opinion is not a conflict of interest. Having a personal opinion is something that people have, and in Canada, I think they have opinions also. I've known.
But when you have but if you're trying to judge something and you have a personal opinion that's going to affect the result of that judgment, it's
Yeah.
more than a personal opinion.
No, it's still an opinion. At the end of the day, it's an opinion. An interest still has to be where there is an outside reason for you to say X or for you to say Y. So, take a Roe v. Wade case where they actually have that in their family. They have, some abortion related case within their family. maybe an action that was deemed necessary in the family that would now be criminalized or vice versa, that may be a different story. But just having an opinion on it, no, I don't think so. I don't see a basis for it. And the source is Jewish or secular. I want to go further because it's 8:30 and we have a whole lot to talk about. Let's say there is a conflict of interest. Not the Facebook case. Facebook, I think we're more or less looking at as just an indicator, if that. But let's say there is a conflict of interest, but the client says, I'm okay with that. I'm willing to continue. Doesn't bother me. So is the lawyer able to represent the client? Or to put it the way I put it in the original vignette, let's say Jonathan really does have a conflict of interest. Is there anything that Jonathan is able to do? So from a secular law perspective, yeah, there is such a thing as consent. So take a look at source number 26 from the Law Society. And this goes back to something that Gary said before when he talked about what he would do as a judge. A lawyer shall not represent a client in a matter when there is a conflict of interest unless there is express or implied consent from all clients, and it is reasonable for the lawyer to conclude that he or she is able to represent each client without having a material adverse effect upon the representation of or loyalty to the other client, and express consent must be fully informed and voluntary after disclosure. So the answer here is sure, just tell them about it, and they have the option of consenting. However, hang on one second. However, take a look at source number 27 where the commentary notes this only works where the lawyer says, I can do this without being influenced. Rule 3.4-2 permits a client to accept the risk of material impairment of representation or loyalty. However, the lawyer would be unable to act where it is reasonable to conclude that representation or loyalty will be materially impaired even with client consent. Possible material impairment may be waived, but actual material impairment cannot be waived. You can't say to the client, yeah, listen, I know it's my sister on the other side, and I'm probably gonna be biased, but if you want, I'm willing to take the case. That doesn't work. Yes, Gary.
I was just going to say there's some rules that you cannot waive consent to. No point getting the client to waive consent because it's against the rules.
Well, it's not waiving consent, it's granting consent. But yes, there are things.
I'm sorry. I meant there's some things you can't ask a client to waive.
Right. And that's right. If you know you're biased.
And a client can give you consent for the matter, but it's irrelevant. There's some acts like that too.
Right.
Clients given certain rights and they can't be waived.
Right.
So a lawyer can't act contrary to that.
And this is one of those areas in which Jewish law and secular law diverge. Because in Jewish law, you actually can consent to basically anything in this regard. If you take a look at Rabbi Yosef Karo in the Shulchan Aruch and the Code of Jewish Law in source number 28, he says it to you right here in the statement, which comes from a Mishnah in the Tractate of Sanhedrin. One who accepts a relative or disqualified party as judge or witness, if there was a kinyan, meaning if there was a formal act done of declaring legal consent, he cannot recant. That's it. You accepted it. Case closed. Your consent is binding. Why? Because remember, our concern about giving bad advice is don't put a stumbling block in front of the blind. This person's not blind. They know you told them exactly, and they chose to accept it. And if you'll say, but it's a bribe, right? Their interest that they have is like a bribe, and it's offensive to justice. Once you accept this person as your lawyer, knowing the conflict, you already foregone the idea of justice here. So Jewish law is more lenient when it comes to the issue of consenting to deal with a conflict of interest. Other side of this, no conflict of interest, like the Facebook case. Do you need to say anything to the, if you know there's no actual one, but there's an appearance. So is there anything required in terms of disclosure? So in the secular system, we've said that it's very important to maintain public confidence, and we should require disclosure. And especially regarding judges. I brought you a case in source number 29, which speaks of the importance of the appearance of judicial impartiality. That becomes very, very important. What about in Jewish law? Well, in Jewish law, there is also a major concern for the appearance of impartiality and concern for causing gossip about the system, even in a case where you don't think that there's really an issue. In source number 30, they dealt with a case going back to the 15th century involving a to'en, in which the story was that there were two parties, technically three, but not relevant for us. There were two parties in a case. One side had hired a to'en, the job of the to'en to make the claims for them in front of the rabbinical court. They're in their proceedings. And then at some point, they dismiss the to'en. The to'en then switches sides and wants to go advise the other side, right? So take a look at source number 30. We'll see it. Yosef Munchen and Shimon and his wife Adel disputed. So you have Yosef on one side and Shimon and his wife Adel on the other side. Each side hired a to'en, this person who's going to assist them. At first, Shimon and his wife hired Aaron Pappenheim as well as Avram Katz as an advisor. He went with them before the court, and Moshe Mintz. A lot of lawyers involved in this case. Later, Avram Katz switched sides and was hired by Yosef Munchen. Moshe, Aaron, and Shimon come to complain before the court. So Rabbi Yisrael Bruna hears this case and the complaint of, hey, the to'en should not be eligible to work for the other side. Why should the to'en not be eligible to work for the other side? What's wrong with the to'en working for the other side?
Because he has all the information from the other side, Rabbi.
Yeah, there you are, Shlomi. He has all the information already. So Rabbi Yisrael says, we ruled not to disqualify him. Not because the situation is good, but because what good would disqualification do? What would be the benefit even if he were not the to'en? Let's say we say, all right, he's not the to'en anymore. Fine. If he wished, he could still tell them whatever he wanted in private. He can do whatever he wants. There's no regulation of his position. So Rabbi Yisrael Bruna said, let him be the to'en. But then he said, you know what? When I came home, I decided, I see your hand, Mark, that if such a case were to come before me again, I would protest. For we find in the Talmud that even if something is permitted, one still should not determine to do it. As Rav Asi said, remove from yourself the curved mouth and distance gossip from yourself. Meaning, you have to be wary of appearances and causing gossip. And the same thing is true in conflict of interest discussions. The to'en case is not a conflict of interest case. But the point is, if there's any possibility that it looks like you have an interest, report it up front. That's the key here. Mark, you were going to say.
I know you were talking about civil, but isn't it the criminal category Altiad Sanigor? Isn't there switching sides? The Tauruses don't do it?
Yeah, but that's a judge. There you're dealing with judges arguing for the criminality or defense of a litigant. That's where that principle comes in. So what we have right now is that both systems are concerned for conflict of interest as a threat to fulfilling your contractual obligation to the litigant, as well as threatening the integrity of the legal system or the appearance of integrity of the legal system. Both sides are concerned about financial and personal interests. There are certain mitigating factors that are accepted in the secular system, unclear how far we would go in the Jewish system, although we do say that financial relationships can terminate. Both systems accept the idea of consent, but the secular system limits consent to situations in which the lawyer is aware that the lawyer can operate without concern for bias. And both systems are concerned about the appearance of conflict of interest, even when there is no actual interest. That brings us to vignette number 2, conflicting out. By the way, I'm going to take a moment now just to mention, again, if you did not register in advance, please make sure that you messaged me to let me know that you are here. I'm also going to add the other side, even though if you're here, you're here. But if you signed up and you didn't come, or you joined for like 5 minutes, I'm relying on you to tell me you weren't here. This is a legal ethics class. So just noting that, putting that out there. Okay. Vignette number 2, deliberately conflicting out the expert or the lawyer. And as I said, it's a frequent tactic in family law, but it has other applications like the case of the expert witness. So secular law really doesn't like it. This goes back to the McKercher case that I noted back in source number 12, where we talked about tactical abuses, right? The rule, disqualification for conflict of interest, applies where the immediate legal interests of clients are directly adverse. It does not apply to condone tactical abuses like let's meet with all the possible experts in order to disqualify them from being involved in the case. This really strikes me as another version of sharp practice, right? We had a session on sharp practice in source number 31. I gave you the link for those who want to check it out. It was November 2019 that we discussed sharp practice. This is technically not sharp practice. Sharp practice is really taking advantage of certain technicalities, but the point is the same, which is you're going to succeed via what the law calls a tactical abuse, not on the merits of the case. Within Jewish law, we also oppose it on principle. Number one, we have a general rule in business which prohibits actions that are meant to harm the other without providing direct benefit to you. I mean, the classic example is what happened with gas prices several years back. If you remember when OPEC was driving down prices in order to knock the shale producers out of the market. So they were lowering prices to the point where they couldn't make a buck either. They're harming themselves. They just know they have deeper pockets and they can take it. The shale producers had to invest a lot in production, and we're gonna have to fold before they would. So lowering your prices in order to drive somebody else out of business is not acceptable in Judaism. And I'm extrapolating from that, generally speaking, practices which are designed not to help you, but just to harm somebody else, competitive violence, are not allowed. I brought you a source on it from the work Erech Shai, a Jewish legal work, in source number 32. He's dealing with it in a business context where you reduce your price in order to harm the other guy, thinking, so I'm not going to gain, but neither will you. Even if you do it in order to get the other guy to pay you something, you're trying to ultimately gain from it. Nonetheless, we say competitive violence is like the city of Sodom, in which you say, I want to make sure that the other guy isn't going to profit. That's no good. And saying, I'm going to knock out all the experts that they can't have the experts is a case of competitive violence. That's number one. But
you
number
do benefit from it.
Yeah. Sorry, Michael, what?
You benefit from it, though.
Yeah.
This is not an instance where you're not going to benefit. You're doing it for your benefit, for your clients' benefit.
You always benefit, but this is not a direct benefit. This is not the kind of benefit. It's not like where you have a loss leader, where you say, I'm going to charge really, pennies on the dollar for something because it'll get people in the door and they'll buy other things and then I'll profit. That is a more legitimate tactic because the benefit is a more direct profit. Here, your benefit is harm to the other guy. Mm-hmm. And that's where it's no good. That's number one. Number two is in Jewish law, we believe that you're supposed to want justice, not victory. So take a look at source number 33, the line from the Talmud. One who leaves the court bereft of his cloak should sing as he walks, right? Meaning you lost your shirt in court. The court decided you lose. You should be happy to lose because you don't want to be a thief. You don't want to win. You don't want to win inappropriately. So coming up with a tactic to defeat the other side by preventing them from getting the expert who's going to testify for them flies in the face of this. Now, I see at least one person looking at me like, seriously? But this is what we do. They, I see you, Sergio. They, nonetheless, this is this is the way that the Talmud looks at it, is that it's a good thing we record video because that look on your face was good. The reality is that from a Jewish law perspective, you don't want to win this way.
But Rabbi, why do people hire lawyers? The people from the general public, they choose their lawyers in order to win. They're not interested in justice. Maybe in the criminal context, that's a little bit different because obviously the prosecutor doesn't have the same role and it's bound by different ethical rules that if there is exculpatory evidence, they have to let the defense know it. You can't be a prosecutor and allow somebody to be convicted wrongfully. That's unethical, and the person that lawyer could be disbarred. But people hire lawyers because they say my lawyer is really good, is going to get me out of this bind, or is going to win my case, and I want a real shark lawyer to represent my case. They don't want somebody who said, no, I just want justice. You know, you would be in breach of your fiduciary obligation towards your client.
So
I guess Vince Lombardi wasn't Jewish.
So what I'm suggesting here is more the client's perspective than the lawyer's perspective. The lawyer can suggest a tactic. Well, no, I take that back. A lawyer should not suggest a tactic that is fundamentally unethical. That's number one. Number two, the client has a responsibility not to pursue a tactic that is unethical. That's from a Jewish law perspective. I grant you that it's possible to make the argument that, well, you're in it to win and let them hire a lawyer and you hire a lawyer, but that's not the Jewish way of looking at it. And frankly, it's not the secular way of looking at it either. Meaning when McKercher says tactical abuses are not being condoned here, they're saying the same thing. You know, like I said before, this is a sharp practice concept, even if it doesn't fit the technical definition of sharp practice.
Well, without getting into that case, because I have read and presented on that case. I mean, it says a whole bunch of other things about the bright line test, etc. But the point being that a client is not bound by any ethical duties. Maybe in Jewish law, but before the Bet Din is one thing. But in secular courts, the client it's not bound by any ethical duties. The client can suggest whatever they want, whether or not the lawyer will participate. That's a different story. The lawyer is bound by ethical duties.
Right.
But the
well, you're talking about
to win is not to have justice.
Well, you're talking about two different things. Meaning, when you're speaking about ethical duties, you're talking about a duty to the bar, a duty to the law society. So of course, it's limited to the lawyer and not the client. I'm talking about a duty to God.
No, for sure.
The lawyer and client are reporting to the same boss.
No, I understand, but also I think that the differentiation is between a civil case that involves a pecuniary interest and a criminal matter, or for example, I can think in the family law context when there is a situation of potential child abuse. That it's those are more, I would say, rise to the level of moral issues. Because in one case, a person shouldn't be convicted wrongfully, and on the other case, I don't think you should allow, knowing that the other parents abuse it, for example, or the situation to be continued. But I think in that case, there is a serious discussion should take place to withdraw the services.
Right. Well, that's right. That's a whole other piece which we're going to touch on maybe. Let me jump to vignette number 3 because I wanted to address this. Like I said in the beginning of the session tonight, this next part, the issue of boundaries, was something I really wanted to deal with in the session we had in December on supporting the emotionally unstable client. and I wanted to do it more fully here. I didn't bring much on the source sheet, but I wanted to have this conversation. So the case that we gave in vignette number 3 is that you have somebody who is a corporate lawyer, has been working for NPO Pharmaceuticals for 7 years, weekly communications, more than that, with the CEO of NPO Pharmaceuticals. And one day the CEO invites the lawyer out to dinner, and the lawyer is feeling uncomfortable. It seems more personal than business. So how does the lawyer, Rhonda, navigate the need to maintain good relations with the CEO? So what we're concerned about, the reason why we're concerned about boundaries here is from the client's side, and I'm making a long story short, but from the client's side, we're concerned. There is the intimacy that comes with confiding in a lawyer. And particularly, and I thank Jeffrey for pointing this out to me, in a corporate situation where there's a long-term relationship between lawyer and client. It's not a particular event, but rather this is a long-term connection. The client feels gratitude towards the lawyer, and the lawyer has a certain attractiveness, a certain charisma. The traits that make the lawyer successful in setting a client at ease, giving support to the client, are the same traits that lend to building a stronger emotional connection. From a psychological perspective, maybe not in a corporate case, but in certain other cases, in certain other types of law, you can even have something that's called in the realm of psychology, transference, where the lawyer is perceived as a protector of the client, and the client transfers their positive feelings for other protectors in their lives to the lawyer. Those are all reasons why we need boundaries from the client's side. But you also need boundaries from the lawyer's side, because the lawyer has temptations for getting too involved, right? The lawyer, first of all, wants to keep a paying client. Let's not forget that. The lawyer develops a feeling of affection for the person that the lawyer is helping. When you help people, you tend to develop a feeling of affection towards them. And if there's transference, where the client transfers feelings towards protectors to the lawyer, there's also countertransference, in which the lawyer is going to assign to the client the positive feelings that they have towards those whom they help. So they start feeling towards the client like they would feel towards a spouse, or like they would feel towards a child. These are our concerns, and the reasons why boundaries become really important, and why Rhonda is right with her concern. Like everybody here said in the beginning, not everybody, but almost everybody who responded to the poll said that they felt that Rhonda was right for being concerned. So how do you navigate it? I gave you in source 34, I gave you 2 useful articles that I found on this. But overall, there are things that a lawyer can do to set effective boundaries. One way to set an effective boundary is to clarify how communication is going to take place. What's the schedule of communication? What's the setting for communication? What are the methods of communication? What's appropriate? What's inappropriate? Setting expectations for what's going to be discussed in each conversation. Will there be small talk? How much time will they spend making small talk? Being predictable and consistent in observing the protocols that you set, so that you stick to it and the client comes to understand these are really firm rules. And then reiterating the boundaries whenever that is perceived as necessary. These boundaries are very important in order to avoid an overstepping. Along with that, the lawyer has to keep an eye on their own conduct and look out for warning signs for themselves. I come to this, again, as all of you know, not as a lawyer, but as a rabbi. This is a monster issue. It's in all the headlines all the time. It's a monster issue for clergy as well. You need to be able to govern your conduct, and not just to govern it, but to watch your conduct. So looking for alterations in your normal communication patterns. Are you giving them more time than you give other people? Are you speaking to them in ways that you don't speak to other clients? Sometimes a client has unique needs, but how much of that is justified in terms of the alterations and the unique status you're giving them? Are you allowing them drop-in appointments that you don't allow to anybody else? Are you giving them unusual leeway in billing? Are you changing the way you dress? You know, you have one way you dress when you're seeing random clients, and then for this client, I'm going to wear something special. That would be a warning sign. Avoiding calling them on problems. If there are things that come up in that relationship, which if they came up in a different lawyer-client relationship, you would say something, but now you don't, that would be a warning sign. And look, well, hang on one second. Looking for that in their contract as well, reciprocally, is very important. Yes, Gary.
I was just going to say, I was at a program once, and the late Edward Greenspan, I think you're old enough to perhaps to remember Edward Greenspan, and he said at the program, a lawyer has to spend, and it was basically the younger lawyers, a lawyer has to spend 50% of his time protecting himself. I would modify that. I think I'd make it about 75%.
Wow. There's a definite concern. I'm going to turn it to the Jewish side to conclude this point, and to say, from a Jewish law perspective, you can make the argument you're a professional. You're focused on being a professional. Rabbi Moshe Feinstein famously said that in source number 35 regarding the justification for seeing a doctor for intimate care. And how can you do that? Isn't there a concern for impropriety? And the answer was, well, the doctor is worried about being professional. The truth is, current headlines show there's reason for concern with doctors and there's reason for concern with lawyers. But what I'm suggesting from a Jewish perspective is that there's a need to take positive steps to set up the right relationship with guidelines for what to expect, as well as to set negative boundaries. The Torah recognizes, and I see we're down to the last couple of minutes, but I think I can fit this in. The Torah recognizes the need for prohibitions against wrongdoing, what we call a lo ta'aseh, and commandments to create a positive atmosphere as well, what we call an aseh. So in the realm of Shabbat, we have prohibitions against performing certain tasks on Shabbat, and we also have a commandment to create an atmosphere of honor for Shabbat. Don't do certain things, do other things. Relationships of parents and children, right? Children have a requirement of awe for their parents. Don't treat the parents disrespectfully, as well as an active command of create a sense of honor for the parent. So in this regard as well, in terms of the lawyer-client relationship, we have the don't do's and we have the do's. So the don't do's are things like don't engage in Jewish law, do not engage in inappropriate contact, don't be secluded together. We have a prohibition in Jewish law against being alone with somebody who's married to somebody else. That's on the don't do's. And then we also have the do's, the actions, the warning signs that we look for in flirtation and the thoughts that you have about the other party and in becoming too casual. We have those rules. So there is setting up the proper relationship, and there are also the things that you want to avoid. There's more to be said. I was hoping to get to it in a little bit greater depth, but at least we got to some of it. And to answer the question we asked in the very beginning about withdrawal, from a law society perspective, as well as a Jewish law perspective, if you feel the client is not respecting the boundaries, then that is grounds to withdraw. You still have to follow all the rules for withdrawal, minimizing the harm to the client. Is going to be very key. Calling it early enough that you're not so far down the road that now they can't start fresh with somebody else. But a lack of confidence due to violation of boundaries is grounds for withdrawal from representation. Okay, thank you very much. I'll stay on for a few minutes if people have questions and comments. Again, if you did not sign in, please make sure to sign in, and I'll be in touch to give you the details for the next session, which is in May, which again is going to be an EDI session. So thank you very much. I wish everybody a happy and healthy Passover, because we're already within the 30 days. Thank you very much.
Thank you, Rabbi.
Good night. Thank you.
Thank you.
Yeah, thanks.
Thank you, Rabbi.